In behalf of my group, good evening. I hope we are all ready to discuss the concept of hearsay rule and the cases relating to it. Okay, so we all know that evidence is the only hearsay if its probative value is not based on the personal knowledge of the witness but on the knowledge of another person who is not in the witness stand. Generally, it is not acceptable and is entitled to no weight at all. Section 36 on testimonial evidence clearly provides that a witness can testify only to those facts which he knows of his personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. However, this admits many exceptions which we all be discussed in this meeting. But first, let us elaborate more on the meaning of the hearsay rule. Again, evidence is called hearsay when its probative value force depends in whole or in part on the competency and credibility of some persons other than the witness by whom it is sought to produce it. As enunciated in the case of Multinational Village Homeowners Association versus ARA Security and Surveillance Agency, the Supreme Court affirmed the Court of Appeals in ruling that the petitioners had no good and valid ground to pre-terminate the contract because the documentary evidence they had presented was hearsay and of no probative value. They failed to produce evidence of the alleged breach of obligation by respondent. The investigation made by petitioner cannot stand as competent evidence. The letter complaints presented in court were neither identified nor were their contents affirmed by the authors. There are three reasons for excluding hearsay evidence. One, absence of cross-examination. Two, absence of demeanor evidence. And three, absence of the oath. These elements are all determinants in the competence and credibility of the witnesses. This is discussed both in the case of Q. Kison versus Court of Appeals and National Development Company versus Workmen Compensation, which both enunciated that self-serving evidence is excluded on the same ground as any hearsay evidence, that is the lack of opportunity for cross-examination by the adverse party and on the consideration that its admission would open the door to fraud and to fabrication of testimony. On the other hand, a party's testimony in court is sworn and affords the other party the opportunity for cross-examination. I mentioned earlier that hearsays being unacceptable admits exception. One of the exceptions to the rules is tying declaration. This is elaborated in the case of People of the Philippines versus Ivero, when the court ruled that while witnesses in general can only testify to facts derived from their own perception, a report in open court of a dying person's declaration is recognized as an exception to the rule against hearsay if it is made under the consciousness of an impending death that is the subject of inquiry in the case. It is considered as evidence of the highest order and is entitled to utmost credence since no person aware of his impending death would make a careless and false accusation. So,
Another case discussing about dying declarations being an exception to the rule against hearsay is a case of People versus De Hoya. For a dying declaration to be admissible, it must be complete in itself. To be complete in itself does not mean that the declarant must recite everything that constituted the res geste of the subject of his statement, but that his statement of any given fact should be a full expression of all that he intended to say, as conveying his meaning in respect of such fact. For dying declaration to be admissible as an exception, these must concur. The declaration must concern the cause and surrounding circumstances of the declarant's death. At the time that the declaration is made, the declarant is under a consciousness of an impending death. The declarant is competent as a witness. And lastly, the declaration is offered in a criminal case for homicide, murder, or parricide in which the declarant is a victim. The case of Suma Chan versus Chua and Sanson versus Court of Appeals, however, discusses the dead man's statute, which provides that if one party to the alleged transaction is precluded from testifying by death, insanity, or other mental disabilities, the surviving party is not entitled to the undue advantage of giving his own uncontradicted and unexplained account of the transaction. But before this rule can be successfully invoked to bar the introduction of testimonial evidence, it is necessary that the witness is a party or a signer of a party, the case, or persons in whose behalf a case is prosecuted. The action is against an executor or administrator or other representative of a deceased person or a person of unsound mind. the subject matter of the actions to claim or demand against the estate of such deceased person or against person of unsound mind, and that his testimony refers to any matter of fact which occurred before the death of such deceased person or before such person became of unsound mind. Another exception to the hearsay rule is a declaration against interest. It is discussed in the case of Sequena versus Volante that a declaration against interest is not admissible if the declarant is available to testify as a witness. Such declarant should be confronted with the statement against interest as a prior inconsistent statement. Section 38 of Rule 130 of the Rules of Court provides that the declaration made by a person deceased or unable to testify against the interest of the declarant, if the fact asserted in the declaration was at the time it was made so far contrary to the declarant's own interest, that a reasonable man in his position would not have made the declaration unless he believed it to be true, may be received in evidence against himself or his successors in interest, and against persons. The admissibility and evidence of such declaration is grounded on necessity and trustworthiness.
And now let us proceed to another exception to the Hearsay rule. Act or declaration about pedigree which is provided in Section 39 of Rule 130. So in the case of Mendoza versus CA, the petitioner denied the private respondent as his illegitimate daughter. So the statement of the okay, sorry for the technical problem. So let us now repeat in the case of Mendoza versus CA. So the petitioner denied the private respondent as his illegitimate daughter. The statement of the trial court regarding Chufesta's parentage is not entirely accurate. To set the record straight, we'll stress that it was an Isaac Mendoza who testified on this question of pedigree, and he did not cite Casimero's father. So his testimony was that he was informed by his father, Hipolito, who was Casimero's brother, and Brigida Mendoza, Casimero's own mother, that Yupesta was Casimero's illegitimate daughter. So such act or declaration may be received in evidence as an exception to hearsay because it is the nature of the case admits and because greater evils are apprehended from the rejection of such proof than from its admission. So another exception to the hearsay rule is the family reputation or tradition regarding pedigree. So in case of Ferrer versus Shaste, it was ruled that entries in family Bibles or other family books or charts, engravings on rings or family portraits and the like to be admissible as an evidence of pedigree. So need not be proven to have been made at the same time as the occurrence of the events documented. So another exception to the rule is the common reputation. So in section 41, it provides that common reputation existing previous to the controversy respecting facts of public or general interest more than 30 years old or respecting marriage or moral character may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. So in the case of Trinidad versus CA, so the petitioner alleged that he is a legitimate child of Innocentes Trinidad, whose estate is being settled. So the respondents denied the relation. So Arturo represented witnesses to prove his position that latter father had been married. So the testimonies by the witnesses constituted evidence of common reputation respecting marriage.
So to continue, next exemption to the hearsay rule is the part of res justae. Res justae is a Latin phrase of things done. This refers to one, spontaneous statements in connection with a startling occurrence relating to that fact and in effect forming part thereof, and two, statements accompanying an equivocal, otherwise known as verbal acts, on the theory that they are the verbal acts of the act to be explained. So in the case of Air France versus Rafael Frascoso, the entry made by the purser in his notebook reading, first class passenger was forced to go to the tourist class against his will and that the captain refused to intervene is admissible as evidence because the subject of inquiry is not the entry but the ouster incident. The utterance of the purser regarding his entry in the notebook was spontaneous and related to the circumstances of the ouster incident. Statements then in the environment when the excitement has not yet died down, growing out of the nervous excitement and the mental and physical condition of the declarant are admissible as part of the rest to stay. Another exemption to the hearsay rule is the entries in the course of business. The rule on entries in the course of business is provided for in Section 37, Rule 130. The admission of in evidence of entries in corporate books requires the satisfaction of the following conditions. First, the person who made the entry must be dead, outside the country, or unable to testify. Second, the entries were made at a near the time of transactions to which they refer. Third, the entrant was in a position to know the facts stated in the entries. Fourth, the entries were made in his professional capacity or in the performance of a duty, whether legal, contractual, moral, or religious. And lastly, the entries were made in the ordinary or regular course of business or duty. In the case of Canque versus CA, the business entries in question did not meet the first and third requisites. There was therefore neither justification nor necessity for the presentation of the entries as the person who made them was available to testify in court. Moreover, Aday admitted that she had no personal knowledge of the facts constituting the entry. She said she made the entries based on the bills given to her, but she has no knowledge of the truth or falsity of the facts stated in the bills. In the case of People versus Leones discussing entries in official records as an exemption to the rule, the written entries in the clinical case record and the diagnosis of are prima facie evidence of the facts therein stated, the said entries having been made in the official records by a public officer in the Philippines in the performance of his duty, especially enjoined by law, which is that of a physician in the government hospital. So in the case at bar, Dr. Antonio Istioco was the admitting physician, but unfortunately, he was not presented as a witness for the government. So another exemption to the hearsay rule is the commercial list and the like. In the case of PNOC versus CA, the price quotations provided by the PNOC as an exemption to the rule are not admissible. Price quotations are not within the purview of commercial lists, as these are not standard handbooks or periodicals containing data of everyday professional need and relied upon in the work of the occupation. So these are not published in any list, register, periodical, or other compilation on the relevant subject matter. Neither are these market reports or quotations within the purview of commercial lists, as these are not standard handbooks or periodicals containing the data of everyday professional need and relied upon in the work of the occupation.
So another exception to the Hearsay rule is the learned treatises. In the case of Ariza versus Toyo, it was enunciated that Philippine courts do not take judicial notice of foreign judgments and laws. A divorce decree obtained abroad is deemed a foreign judgment, hence the indispensable need to have it pleaded and proved before its legal effects may be extended to the Filipino spouse. This rule is rooted in the fundamental theory that Philippine courts do not take judicial notice of foreign judgment and laws. In this case, the English translations submitted by petitioner are not advertised as a source of official translations of Japanese laws. In the case of Manliklik versus Kalaunan, hearsay evidence alone may be insufficient to establish a fact in issue, but no objection is interposed thereto. It is like in any other evidence to be considered and given the importance it deserves. Now let's proceed to opinion rule. In the case of People versus Martinez, it is a standing doctrine that the opinion of a witness is admissible in evidence on ordinary matters known to all men of common perception, such as the value of ordinary household articles. So here, the witness is not just an ordinary witness, but virtually an expert, since his work as investigator of crimes against property has given him both exposure to and experience in fixing the current value of such ordinary article subject of the crime at bar. So incidentally, it is significant that appellant never dared to cross-examine on the points involved, which opportunity to cross-examine takes the testimony of SPO4 Castro out of the Hearsay Rule, while the lack of objection to the value placed by Spio for Castro bolstered his testimony under the cited exception to the opinion rule. Now, I believe we are near to the end, so let makes it fast. So in the case of Civil Service Commission versus Bilagan, discussing a character evidence, generally the character of a party is regarded as legally relevant in determining a controversy. Seller is the principle that evidence of one's character or reputation must be confined to a time not too remote from the time in question. In other words, what is to be determined is the character reputation of the person at the time of the trial or prior to, but not at a period remote from the commencement of the suit. Hence, to say that the witness credibility is diminished by proofs of tarnished reputation existing almost a decade ago is unreasonable. So it is unfair to presume that a person who has wandered from the path of moral righteousness can never trace his steps again. Certainly, every person is capable to change or reform. So lastly, we are able to tackle to tackle the rule on examination of a child witness. So in the case of Janelle versus Rivera, it was ruled that when a child testifies, the court may motu proprio order the exclusion from the courtroom of all persons who do not have a direct interest in the case. So in issuing such order, the order is to consider inter alia the following: first, the development level of the child; second, the nature of the crime; the third, the nature of his testimony regarding the crime. So it may also exclude the public from the courtroom if the evidence to be produced is of such character as to be offensive to decency or public morals.
So I think that is the end of our report. So thank you, group mates, for elaborating your cases. That's all. Good evening.